Welcome once again to Lehto's Law. Here's Steve Lehto.
Very interesting story out of Reason.com. Reason.com. Paul and Jeremy both sent this to me, and this is troubling to a lot of people, understandably so. A court case could make it a crime to be a journalist in Texas. Now, they're not going to outlaw journalism, but they have a law that says that journalists cannot report on certain things. And there's now a fight breaking out at the Court of Appeals on whether or not such a law could be lawful. So Billy Binion wrote the story for Reason.com, and he says it's been 5 years since police in Laredo, Texas, mocked and jeered at Priscilla Villarreal, a local journalist often critical of the cops, as she stood in the Webb County Jail while they booked her on felony charges. Her crime was, of course, just simply asking questions of the government. Now, this may seem like a relatively obvious violation of the First Amendment, yet perhaps more fraud is that after all this time, the federal courts have still not been able to reach a consensus on the question. She was arrested for something she reported, and the courts are confused. Is that wrong, that she should be arrested for that? Over the years, judges in the Fifth Circuit, which is where Texas is, have ping-ponged back and forth over whether jailing a journalist for doing journalism does in fact plainly infringe on her free speech rights and, of course, the freedom of the press. The U.S. District Court for the Southern District of Texas awarded the officers who arrested her qualified immunity, the legal doctrine that allows states and local government officials to violate your constitutional rights without having to face federal civil lawsuits if the violation has not been clearly established in case law. So is there any clearly established law suggesting that a journalist has the right to report things? The U.S. Court of Appeals to the Fifth Circuit forcefully overturned the lower court and said, if this is not an obvious violation of the Constitution, it's hard to imagine what would be. And that's the judge who wrote the opinion from the Fifth Circuit. So you say, Steve, the Fifth Circuit seems to agree. Well, there's a problem there. Because the way circuit courts work, and the Fifth Circuit, I believe, has 17 judges, or at least 17 active judgeships. And when you go up on appeal, they pull a panel of a few judges. And that panel votes on your case. And when they have an opinion, one of those judges writes the opinion. So one of the judges on the smaller panel wrote the opinion saying, if this is not an obvious violation of the Constitution, it's hard to imagine what would be. But there's a process whereby the entire group of judges, all 17 of them, can revisit a case en banc, as they say, which is Latin. And if all 17 of them review it, they then vote, and it's a majority of the 17 that would get you a win. Okay, so you'd need 9 justices out of the 17 to vote your way. The weird part about this is that the judges appear to have done this on their own and decided to rehear this case en banc, and that is often an indication that the other judges think that the first panel was wrong. Last week, the full spate of judges on the Fifth Circuit voted to rehear the case in a rare move that signals discontent with the conclusion that the previous judge had written. Put differently, it's not looking good for Villarreal, nor for any journalist in the Fifth Circuit who would like to do their job without fear of going to jail for it. Now, here's what happened. In April of 2017, Villarreal, who reports near the U.S.-Mexico border, broke a story about a Border Patrol agent who committed suicide. A month later, she released the name of a family involved in a fatal car accident. The agency that confirmed both of those pieces of information was the Laredo Police Department. So the information came to her from the police. They confirmed this information to her. The agency that would bring felony charges against her 6 months later was the Laredo Police Department. So the same department that had leaked her the information arrested her on felony charges for reporting the information that she got from them. At the core of this misfortune for her is a Texas law that allows Texas to prosecute someone who obtains non-public information from a government official if he or she does so with intent to obtain a benefit. Now, she operates her popular news sharing operation on Facebook, where her page has amassed 200,000 followers as of this writing. So to jail her, Police allege that she ran afoul of that law when she retrieved information from a Laredo Police Department officer and proceeded to publish those two aforementioned stories because she potentially benefited by either gaining more Facebook followers or somehow getting some benefit from the fact that that helps her page. Missing from the analysis, of course, is that every journalist, reporter, or media pundit has an intent to benefit when she or he publishes a story, whether it is to attract viewers, readers, subscribers, or simply drawing a paycheck as a reporter. Soliciting information from government officials is often called a scoop, and of course, it's not new. And by the way, there are often whistleblowers inside government agencies that leak the information out because they want it to get out, but they're scared of what will happen to them if they get it out. Now, this was an argument that in some sense resonated with the chief judge on the Fifth Circuit, who almost certainly voted in favor of reconsidering the court's opinion. In fact, Villarreal's complaint says that she sometimes enjoys a free meal from appreciative readers, occasionally receives fees for promoting a local business, and has used her Facebook page to ask for donations for new equipment necessary to continue her citizen journalism efforts. And that's what she wrote back in August when she was arguing against the opinion by the other judge. With great respect, the majority opinion is off base in holding that no reasonably competent officer could objectively have thought that Villarreal obtained information from her backdoor source within the Laredo Police Department with an intent to benefit. Such an interpretation, of course, would render the media industry an illegal operation, and everyone who participates, whether they be conservative, liberal, far left, far right, or anything in between, criminals. Other journalists are paid full salaries by their media outlets, writes the judge who originally ruled in her favor. Is that somehow less consequential than receiving a free lunch or getting a new spike of followers on a social media platform? In some, it is a crime to be a journalist in Texas, thanks to the dissent's reading of the code, and that is what the judge wrote. The judge actually said doing that would make it a crime to be a journalist in Texas. Now, debates around free speech are often polarized along predictable partisan lines. More specifically, they're often polarized by the content that they're being pushed. It's an easy task to support the idea of free speech when you enjoy what's being said, but of course, when they're talking about you don't like it. So the First Amendment does not pertain solely to popular speech, which by nature of common sense needs considerably less protection than the content deemed unpopular by the majority. A senior attorney at the Foundation for Individual Rights and Expression said it's not about just one person, it's not about just one case. It's about the First Amendment rights of all citizens to ask their public officials questions. And so here's the thing. I say that occasionally. Someone's going to say, Steve, if someone leaks information to a journalist and the journalist publishes it and they shouldn't do that, that's a problem. Why don't we step back for a split second here and look at what the real problem is? If there's something bad happening at the police department and somebody leaks that to the press, the problem ain't the press. The problem is the problem at the police department. But I know what some people are going to say. Some people are going to say, Steve, you don't understand. If people are leaking things to the press and they shouldn't be leaking them, the press shouldn't be publishing them. And I bet about half of you caught that right there. If somebody shouldn't be leaking them, they shouldn't be leaking them. And so what's the real problem? Let's go with the notion that the law makes sense, which I think is a stretch, because the law doesn't make any sense. But let's suppose the law made sense. And you wanted to stop confidential information from being published after being leaked by the police department, the Department of State, Secretary of State's office, the governor's office, the mayor's office, whatever it is. You want to stop those leaks. Outlaw the leaks. Now you're going to say, Steve, that's the same thing. No, it's not. Because there are government officials who are handling important information. And if the law requires them to handle that information in a particular way and they mishandle it and give it to a journalist, go after the person who mishandled the information, not the journalist. And there are laws out there that protect confidential information. And so I mentioned a couple days ago, for instance, I'm just picking one out of thin air here, is that if you file a complaint with a court, you do not put a defendant's social security number in the pleadings. And it's because it's considered to be, number one, it's unnecessary, but number two, it would be taking personal information and publicizing it, making it available to public. And there's a rule about that. And if someone breaks that rule and the information gets put there, the person at fault is who put it there wrongly. So if a police department actually has confidential information that's being leaked to the press by somebody at the department, find that person, and if they're breaking the law, you go after them. If they're breaking the law, okay? If they're not breaking the law, then it would seem kind of odd that it'd be illegal to publish what was leaked if the leaker didn't do anything wrong. So this is a strange case, and this is the kind of case that if the Fifth Circuit decides to overturn the judge who said this is an obvious violation of the Constitution, I hope it goes up to the Supreme Court, but I don't know what will happen there anymore. I really don't. It is very hard to predict these days, okay? And they might not even take the case. But the weird part is that there's an obvious solution. And I'll give you another example. Medical records. There are laws regarding how medical records are handled, okay? So if somebody at a doctor's office is leaking this information to other people who are then disseminating it somehow, you can go after the people who are disseminating it, but you can shut it off at the source. Find who's leaking the information and go after them. And if you can't go after them, well, then maybe you should pass a law that you can. But I suspect there already is one. And it ain't working because there's people who are still leaking stuff to journalists despite the fact that it's probably against the law. So here we are, and you want to stop this at the furthest point downstream when you could stop it at the source, which would be easier, presumably. So do keep in mind that on the same topic, there are laws that protect whistleblowers, but whistleblowers only address certain kinds of things. So you can't leak anything you want and go, I'm a whistleblower. But the point is that there are laws that address what you can and cannot release to other people or leak to people or disseminate elsewhere. And the idea that they say, well, you can't take this information and publish it if you're going to gain from it, that would address all journalists. So journalists could no longer take information that was handed to them on the sly in Texas. And that would be a little crazy. So we'll see what happens here. But the bad news is that she had gotten a good ruling originally from the Fifth Circuit Court of Appeals, but that was from a smaller panel. And now the entire panel is going to revisit this. And that suggests that there are people on that panel who want to overturn that ruling. And so we'll continue to follow this and see what happens. But Paul and Jeremy both sent this. Thanks a lot. Billy Binion wrote that for Reason.com. And this court case could make it a crime to be a journalist in Texas. And no, that is not hyperbole, because that's exactly what the judge said. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Meaning of reference manual. Object that raises the monitor to eye level.